Rhode Island has a tenant protective late fee framework with a specific statutory provision that limits what landlords can charge. The governing law is found in the Rhode Island Residential Landlord and Tenant Act, Rhode Island General Laws, Title 34, Chapter 18, along with general contract principles. If you're a landlord or tenant in Rhode Island, the state provides clear rules that restrict late fee amounts and require a grace period. Let's start with the key rule. Under Rhode Island General Laws, Section 34, 18 to 15, the landlord cannot charge a late fee until the rent is 15 days or more past due. This is one of the longest mandatory grace periods in the entire country. If rent is due on the 1st, the late fee cannot be imposed until the 16th. The 15-day grace period is mandatory. The lease cannot shorten it. This extended grace period fundamentally changes the late fee dynamic compared to most states. A tenant who pays on the 10th, which would trigger a late fee in most states, is not late under Rhode Island law. A tenant who pays on the 14th is still within the grace period. Only a tenant who fails to pay for more than 2 weeks after the due date can be charged a late fee. Rhode Island does not impose a specific statutory dollar cap or percentage cap on late fees. There is no rule that says the fee must be under a certain amount or percentage. However, the general reasonableness standard applies. The fee must bear a reasonable relationship to the landlord's actual damages from the late payment. A fee that functions as a penalty rather than compensation for actual costs can be challenged under Rhode Island's consumer protection framework. What's reasonable in Rhode Island? Given the state's 15-day grace period, which means the landlord has already absorbed 2 weeks of delayed payment before any fee applies, the actual damages from the additional delay are more limited than in states where the fee kicks in after 3 to 5 days. Industry standards suggest that a flat fee of $25 to $50 or a percentage-based fee of 5 to 8% of the monthly rent is generally defensible in Rhode Island. The 15-day grace period arguably makes higher fees harder to justify because the landlord has already demonstrated they can absorb a 2-week delay before any fee is triggered. The lease must clearly state the late fee terms. The fee amount, the 15-day grace period, and the conditions for imposing the fee must be documented in the rental agreement. A late fee that isn't specified in the lease is not enforceable. Rhode Island courts require clear written terms. Oral agreements about late fees are insufficient. Rhode Island's Deceptive Trade Practices Act provides an additional enforcement mechanism. Tenants who are charged late fees in violation of the 15-day grace period or who are charged unreasonable fees can pursue claims under the Act. The potential for damages beyond the fee itself creates meaningful risk for landlords who don't comply. Compounding late fees in Rhode Island must be evaluated in the context of the 15-day grace period. Since the fee can't begin until day 16, a compounding structure that starts on day 16 and accumulates daily or weekly charges must still produce a total that's reasonable. A daily fee that begins on day 16 and runs through the end of the month only has about 15 days to accumulate, which limits the total. But the compounding structure must still satisfy the reasonableness standard. Most Rhode Island landlords use a single one-time fee after the 15-day grace period, which is the simplest and most defensible approach. The interaction between late fees and the eviction process in Rhode Island follows the state's landlord-tenant framework. Rhode Island requires the landlord to provide proper notice before pursuing eviction for non-payment. The amount demanded must be accurate, including only legally compliant late fees charged after the 15-day grace period. Including fees that were imposed before the grace period expired invalidates the fee and can complicate the eviction. Whether unpaid late fees can be included in the eviction demand depends on how the lease defines them. If the lease defines late fees as additional rent, they can be included. If not, the landlord may need to pursue the fees separately. Best practice: define late fees as additional rent in your lease. Rhode Island's eviction process is moderately paced, not as fast as states with 3-day notice periods, but not as slow as heavily regulated states. The 15-day grace period means that by the time a late fee is triggered, the landlord is already well into the timeline for addressing the non-payment, whether through communication, demand notices, or the beginning of eviction proceedings. In practice, the late fee and the eviction process often run on parallel tracks. Rhode Island limits the security deposit to 1 month's rent. The deposit must be returned within 20 days of the tenant vacating. Unpaid late fees can be deducted from the deposit if the lease authorizes the deduction and the fees are compliant, meaning they were charged after the 15-day grace period and are reasonable in amount. Deducting fees that violate the grace period requirement from the deposit compounds the violation. For tenants receiving housing choice voucher assistance, Rhode Island landlords should not charge late fees when the housing authority's portion is delayed due to processing. Rhode Island's 15-day grace period already provides substantial buffer, but even with the extended grace period, the tenant should not be penalized for the authority's administrative delay. If the tenant's portion is paid on time, no fee applies regardless of when the authority's portion arrives. Rhode Island's military population is centered around Naval Station Newport, which houses the Naval War College, Officer Candidate School, and various other Navy commands. Military pay is predictable, and most military tenants pay reliably. The 15-day grace period comfortably accommodates any minor military pay processing delays. SCRA protections may apply to service members experiencing financial hardship. From a practical standpoint, Rhode Island's rental market is small but tight, and the 15-day grace period affects landlord operations differently than in most states. Providence is the dominant market. The economy is driven by healthcare, higher education, Brown, RISD, Johnson and Wales, Providence College, government, financial services, and the creative economy. Providence's tight market means that most tenants pay on time. The 15-day grace period is a safety net that most tenants don't need. For the minority of tenants who consistently pay between day 6 and day 15, the landlord receives the full rent, just later than preferred. The late fee only kicks in for tenants who are genuinely delinquent beyond 2 weeks. This dynamic means that Rhode Island landlords should focus less on late fee revenue and more on screening and tenant selection. In a state where you can't charge a late fee for the first 15 days, the best protection against chronic late payment is selecting tenants who pay reliably, not depending on fee income from tenants who don't. The student population in Providence is enormous relative to the city's size. Student tenants whose financial aid is delayed may pay late, but the 15-day grace period typically covers the processing delay. Most financial aid disbursements clear within the first 2 weeks of the semester. For the rare student whose aid is delayed beyond 15 days, the late fee applies, but the amount should be reasonable. Warwick, Cranston, and Pawtucket share Providence's general dynamics. Newport has a military-influenced market where payment reliability is high. The seasonal shore communities have tourism-driven dynamics where seasonal workers may have irregular income. Woonsocket, Central Falls, and some of Rhode Island's smaller communities have more affordable markets with higher proportions of lower-income tenants. In these communities, the 15-day grace period provides particularly important protection. Tenants waiting for Social Security, disability payments, or other benefits that arrive mid-month have time to pay without penalty. One best practice for Rhode Island landlords: train your team on the 15-day grace period and enforce it rigorously in your own procedures. Do not send late fee notices or charge late fees before day 16, even if the fee is modest and the tenant doesn't dispute it. Charging before the grace period expires is a violation that creates liability. Set your accounting system to flag day 16, not day 2 or day 6, as the late fee trigger date. Another best practice: given the 15-day grace period, focus your late payment management on communication rather than fees. If a tenant hasn't paid by day 5 or 6, a friendly reminder call or text costs nothing and often resolves the issue. By day 10, a more formal written communication is appropriate. If rent is still unpaid by day 15, you know you're dealing with a genuine payment problem, and the late fee kicks in on day 16 as one of several tools for addressing it. A third best practice: use the 15-day grace period as a screening differentiator. When marketing your property, the extended grace period is a tenant-friendly feature that attracts responsible renters who value flexibility. Most tenants will never use the full 15 days, but knowing it's there creates goodwill and can give your listing an edge in a competitive market. For the complete guide to Rhode Island late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.